everyone. I'm Elizabeth Wydra, president of the Constitutional Accountability Center, and welcome to our end of 2021 Purple Chair Chat. I'm so delighted to be joined today by Praveen Fernandez, CAC's vice president. Welcome, Praveen.
Thank you so much. It's so great to be here, Elizabeth.
So normally we would be in our offices in our iconic purple wing chairs. That's why it's called the Purple Chair Chat. But like so many of you, we are working from home right now. And, as we mark a very grim milestone in the pandemic, we also are hoping that we and all of you can find some hope in this season. So Praveen, we had a big year at CAC. It's hard to get through everything we did just in this short show, but there are some highlights that we'd like to talk about. And one of the things that I really loved as someone who's been with CAC since the very beginning was the 10-year anniversary reissue of a publication called Laying Claim, which was CAC's really kind of planting its flag in the conversation about the Constitution and talking about how its text and history can be deeply progressive. We have a clip from the event that we did this year, and then I want to talk more about it with you.
If we look across the span of history at the places where judges have gerrymandered text and sort of gone outside of what the text says, it has most often not been to the benefit of racial minorities or poor people or people who are not politically connected, but rather to the advantage, right, of the powerful, the racially privileged, and the wealthy. And we can see it perhaps most prominently in the context of judges adding non-textual limitations to some of the truly revolutionary statutes that were intended to upend status relations in this country and to benefit historically subordinated groups. So across all of these contexts, it can allow inequality to leak in and the law to mean one thing for the rich and the powerful and something else for everybody else when we don't treat text as our lodestar.
So as you can see, Professor Katie Iyer there is talking about the ways in which sticking to textualism when it comes to the law can be beneficial, and deviating from text and history can be detrimental to our struggles for equality and justice. Why is this publication and its message still so important 10 years after we first published it?
Yeah, thank you, Elizabeth. And I should say thank you also to you, because you submitted an introductory essay for this publication. And Professor Katie Iyer was also joined by Professor Alexis Hogue to sort of add new introductory essays. I think this publication is important because it adds two new scholarly voices in areas that people have not associated with strict adherence to text and history, whether we're talking about statutory text. And Katie Iyer's work, Professor Iyer's work, has done so much for LGBTQ advancement in that area. And of course, Professor Hogue's work has done so much in the area of criminal justice, particularly as it affects Black and Brown communities. And so you see two scholars whose work has really advanced progressive issues that are dear to progressives' hearts, but using methodology that at least 20 or 30 years ago, people falsely associated with conservatives because of its genesis. And I think, 10 years after, Laying Claim was introduced, it's no less important to make sure that progressives know that they don't have to choose between embracing text and history and the issues and outcomes that they care deeply about, that we all care deeply about.
Yeah, I think that's exactly right. And, we work to show how powerful it is when you root claims to equality and liberty and justice, when you root claims for progressive change directly in the text, history, and values of the Constitution. And that is perhaps more important than ever with many of the fights that we are currently facing right now, some of which we're going to talk about. One of those key battlegrounds, of course, is the fight over democracy and the rule of law. And CAC has been involved in that in many different ways. And I'm delighted that we'll be bringing on our team member, Smita Ghosh, to join us to talk about this. Welcome, Smita.
Hi.
Well, so Smitha, thanks so much for joining us. Elizabeth sort of tipped her hat towards this, at least metaphorically. No hats on today.
Yeah.
But we're approaching an anniversary, almost a year, if you can believe it, since the awful and tragic events of January 6th. And that represented something that many of us felt was unexpected, not only as an assault upon the Capitol building, but the democracy for which it stands. And there has been a bipartisan committee that was established, the Select Committee, to really investigate what happened that day, what were the events that led up to it, and of course, to consider and instruct and inform Congress as they figure out what needs to be done to make sure that this never happens again. And so the Select Committee has been doing amazing work, looking at like thousands of documents that they've already received and hundreds of depositions and interviews that they've already conducted. With the vast majority of individuals who've complied with requests from the committee to make sure that the American people and really get the answers that they deserve and that they want. But there have been some parties that have resisted this attempt to really find out that information that's critical to Congress and the American people. Can you tell us about one of the lawsuits that the litigation team at CAC was key to?
Yeah, of course. And I'm zooming out a little bit. I'm really glad that you mentioned that the Select Committee is investigating this series of pretty devastating attacks on January 6th, because I think we think of Congress making laws a lot of the time, but kind of don't remember that a big part of that legislative process is investigating the need for new laws and pulling together the information needed to figure out where future legislation can go to prevent terrible things from happening or to make people's lives better and stronger. So in this case, Trump versus Thompson, it's one in a series of cases about Congress's ability to investigate. And it is one in a series that involves President Trump's objections to that power to investigate. He objected both as president and now as a former president. And I think what we added to the litigation here is just to say that Congress has always had this power. And as you said, most people, first of all, it's necessary for their ability to make laws. And most people have always considered it part of their public duty to comply. And what Trump is saying and objecting to it is that either as president or former president, he's above that law and above that public duty. So situating those objections in this like grand history of Congress's investigative power really shows how kind of off the wall his claims are. We filed a brief in the DC Circuit in this particular case about Trump's records pertaining to January 6th, which, as you said, were sought among a series of records from that Select Committee. And I'm happy to say that when a panel of the DC Circuit heard that case, they agreed with both what we were saying as CAC on behalf of a bunch of former Department of Justice officials and also members of Congress who were seeking this information. They rejected the claims that Trump was making that the information sought here is privileged and that, again, as former president, he should be sort of exempt from this duty to help Congress in its investigative journey.
Thanks so much for that explanation of the case and the issues that were involved. You're right that it was a resounding victory, for the American people, for Congress's ability to get the information it needs to do its job under the Constitution. One thing I will add is, Smitha, you had mentioned that it was the amicus brief that we filed was filed on behalf of Department of Justice high-ranking officials. But one thing I would add to that is those were Department of Justice high-ranking officials who had served in Republican administrations. And
absolutely.
I think one of these wonderful sort of demonstrations of the work that is done at CAC, not just in terms of putting forth arguments, but finding messengers that can resonate with the court, and in some sense showing why this is a departure not from progressive or conservative understandings of the balance of power between the branches, but really a departure from bipartisan understandings, honestly, about the way our government functions and the way our three branches function with each other.
Absolutely. It's not, I hope our brief made clear that it's not really a partisan issue. Presidents on both sides of the aisle have participated in information sharing when it's been determined to be useful for Congress or the public in general. So this was really unprecedented, and especially the DC Circuit, in its opinion, made clear that Trump's objections were pretty vague. It wasn't about particular pieces of information that were going to be released that might have a kind of harmful impact on national security or gives, state secrets. It was just, he just didn't give enough information to really override that important role of investigating and sharing information with Congress when it needs to make new laws.
Yeah, thank you so much, Smita. I think as Praveen pointed out, the work that you and your colleagues on that brief did was really fantastic and done on a really tight time frame. And so, we're really grateful for that. And, as our discussion shows and the DC Circuit ruling in this case shows, we can win some victories in the courts, but we are facing a judiciary that is has been Trumpified, for lack of a better word. Praveen, what does the situation look like right now for us in the courts? And I guess, what do you see? Because I think there are a lot of reasons for hope. What do you see as a reason for hope when we look at the landscape of the judiciary right now?
Sure, such a good question, and you're exactly right. As we ushered in the beginning of this year, I think we were looking at a very, very grim judicial landscape. As folks might know, roughly a fourth of all active judges in the federal bench had been Trump appointees at the beginning of this year. I don't mean conservative appointees or appointees appointed by Republicans. I mean Trump appointees. And I think what that pointed to was the emphasis the Trump administration had placed and Senator Mitch McConnell had placed on both naming judges and getting them confirmed. And so, we had that situation writ large across the federal bench. And then obviously at the Supreme Court, this is a problem that was covered more extensively in the American public. We had 3 justices who were named during the Trump administration. So that's a third of the Supreme Court that was named during the Trump administration. So a very grim picture as we entered the year. What I'm happy to say to folks, and we look for these rays of happiness, is that I think the Biden administration has been a corrective to something that I think has plagued prior progressive administrations who did great work, but I think most would agree didn't really prioritize the judiciary in the way that conservative administrations often did. And I'm happy to say that the Biden administration has made nominations with astonishing speed. And so in terms of numbers, they have really picked up the pace, brought through a ton of amazing nominees, and the Senate has confirmed them. And so that is wonderful to see in the first year of the administration. And of course, it's not just a numbers game. And perhaps we can talk about this a little bit more back and forth. But I think you'll agree with me. It's not just a number of really fantastic judicial nominations, and many of whom, now that they're confirmed, are now on the bench. But it's also, addressing issues of diversity. And the Trump nominees, aside from being conservative, were also in the main predominantly white and male. And these nominees are incredibly diverse in terms of, bringing us a little bit closer to what America looks like and having a bench that reflects the American public. And aside from that kind of demographic diversity, also adding experiential diversity to the bench. And I know you know this, having been a litigator, but there's some professional backgrounds that are over-indexed when we look at the federal bench, corporate law backgrounds, et cetera. And so When you look at the new crop of nominees, there are public defenders, there are civil rights lawyers, there are voting rights advocates who are joining the bench, and they are filling in gaps in terms of careers into the bench, and they will bring that understanding to the adjudication of cases, and that will help the rigor of judicial decision making.
Absolutely. I think it's been something that has been a huge bright spot, the way that the Biden administration has been putting civil rights lawyers, public defenders, labor lawyers, a vast diversity of nominees, and they're getting them confirmed. And, I think that is something that it's important to remember when we talk about especially how dark things look when we look up to the highest court, the Supreme Court. And certainly one of the areas where I think many of us are extremely concerned, and rightfully so, is when it comes to fundamental rights of equality and liberty. And perhaps no right is more at stake at this term in the Supreme Court, and at the intersection of racial justice and reproductive liberty than abortion rights. And we had a great conversation earlier this year with Monica Simpson, the head of Sister Song, an amazing organization that does abortion rights and liberation advocacy. And we have a clip from that conversation that I'd like to bring up.
The frame of reproductive justice gives us the ability to look at this work with an understanding that abortion justice is connected to our overall liberation and our bodily autonomy as Black people and people of color in this country. And, I always quote the amazing Audre Lorde that says we can't have single issue movements because we don't have single issue lives. And to me, that's the epitome of what reproductive justice is all about.
So incredibly wise and powerful words from Monica Simpson there. CAC, of course, has been involved in these fights, and we are in both of the big Supreme Court cases that deal with abortion rights that have already been filed. And I'm delighted that one of our counsel, Miriam Becker Cohen, is joining us to talk a little bit more about the work that we did specifically in the SB 8 Texas case, which really brings home, I think, both the extraordinary legal consequences of this fight, and also brings it down to the very real personal consequences of what this means for people who are being denied these rights. Miriam, thank you so much for joining us, and thank you for your work on this issue.
Thank you for having me.
So talk a little bit about the arguments that CAC has made in our brief and why they are so powerful when we think about this intersectional struggle that Monica talked about in that clip that we showed.
Yeah, absolutely. So there were actually two lawsuits challenging SB 8, one filed by the federal government against the state of Texas, and another filed by a group of abortion providers and advocates against various Texas state officials. And we filed briefs in both cases, and I think both of them really illustrate the gravity of this issue and why it's so important for the federal courts to be protectors of fundamental rights, including the right to abortion. In the case brought by the providers, in which the Supreme Court recently issued a decision, we talked, our brief really focused on the constitutional structure and the purpose of the Supremacy Clause and the role of federal courts in protecting federal rights. A lot of the defendants, all of the defendants, in fact, in this case have advanced the argument that basically they can't be sued because they have no role in enforcing SB 8, because SB 8 was designed to specifically delegate enforcement power to private parties. That was all part of the scheme that Texas came up with to make this law immune from judicial review. And our brief said basically the text and history of the Constitution make very clear that federal courts are the protectors of federal rights, and Congress enacted this statute, this landmark statute, Section 1983, in order to allow people to vindicate their rights. And that is such an important statute, and I think really bears on the intersectionality of this issue, because Section 1983 is not just used to enforce abortion rights; it's used to enforce all sorts of civil rights, including rights that further racial justice in this country, and was such a powerful tool during Reconstruction. So our briefs in both cases talked a little bit about the history of Section 1983 and why that statute is so important to the abortion movement and also broader the progressive constitutional movement.
So we've had a ruling in the initial SB 8 cases, which, as you mentioned, were about whether the suit could even be brought against this unquestionably unconstitutional law. It was disappointing in many respects, and certainly one of the, even though it let a shred of the lawsuit move forward, it was disappointing in the way that it interpreted the law, which could be detrimental to enforcing rights in the future. And also because of the sort of bad signals it sent for the right to choose abortion, to access abortion overall, which will be coming up in the Dobbs case, of course. Just briefly, I want to talk about CAC's argument on the actual right to abortion, because I think it's so powerful, and it's one that isn't always front and center when it comes to the progressive messaging on abortion. Can you talk a little bit about that text and history argument?
Sure. And this is an argument that we really get into more in our brief in Dobbs, which is a case that, as you said, is about really whether the right to abortion as it exists now will continue, as opposed to these lawsuits in SB 8 were really about not the merits of the law, which is undoubtedly constitutional, but whether individuals harmed by that law could step into court to fight against it. And CIC's argument really comes from the fundamental concepts of substantive liberty and dignity and bodily autonomy embedded in the 14th Amendment. Those concepts were so important to enactment of the 14th Amendment and so important during Reconstruction in the sense that so much of Reconstruction was about vindicating the rights of formerly enslaved people who lacked bodily autonomy and who were abused in ways that prevented them from exercising their right to liberty. And so much of that is so deeply connected to the right to control one's body and one's reproductive future.
Yeah, absolutely. Thank you so much, Miriam. Thank you for your work on this and other issues.
Thanks for having me.
So Miriam referenced Section 1983, this critically important civil rights law. And CAC has also done work this year, as in other years, but this year we've done a really great, I think, piece of scholarship authored by David Gans, who is joining us to talk about his work on Section 1983. Welcome, David.
Thanks, Elizabeth. Thanks for having me.
Yeah, welcome, David. I feel like this is such a continuation of the amazing scholarship that you had unveiled, the year prior, really looking at the history in the policing context of the 14th Amendment language and how it fleshed out our understanding and enriched our understanding of other criminal justice provisions, such as the Fourth Amendment search and seizure provisions, and why the mining of 14th Amendment history was so important for judges, scholars, and advocates to understand as they address the issue of awful, awful police abuse against Black and Brown communities. And this year, of course, you did this piece of scholarship on this landmark civil rights statute. Could you tell us a little bit about Section 1983 and also what the purpose was of this piece of scholarship this year?
Sure. So the 14th Amendment changed the Constitution, but Section 1983 changed our court system. It was passed 150 years ago in the wake of brutal racial violence by the Klan and other white supremacist groups that were essentially frustrating the promise of liberty and equal citizenship that the 14th Amendment had written into the Constitution. And it changed the courts by saying, as an individual, you can go and sue state or local officials or the government itself for violating your constitutional rights when they are using official abuse of authority to take away fundamental rights that are guaranteed by the Constitution, including by the 14th Amendment. And it was this was a measure that was designed to enforce the 14th Amendment and to ensure that our courts had the power to enforce constitutional rights and make the rule of law a reality. And it was quite clear at the time that when they wrote this statute, there was no conception that just because you were employed by the government, you were immune from being sued in court. There were actually lengthy debates that related that, and there were some who said, "Oh, officials should be given some kind of immunity. They shouldn't have to face accountability in the courts." And the authors of those statutes, essentially the same people who wrote the 14th Amendment, said, no, that would be like going back to the English idea that the king can do no wrong, would put officials above the law. So if you look at the history of Section 1983, the idea was ensuring accountability, ensuring that individuals could go to court and hold officials and governments liable when they violated the Constitution. That was kind of a central precept that was written into our federal law.
Thank you. That's so important, and getting that historical record out and understood correctly by the audience of readers, policymakers, jurists is so important. And of course, as Elizabeth already said, it's relevant in ways in ways that folks might have found unexpected 2 years ago, because of course the architects of the SB 8 legislation, in fact, were pretty upfront about the fact that how they designed that statute, that state statute, was specifically to be an end run around the kinds of accountability that you just described for state actors under Section 1983.
I mean, I think that's exactly right. Section 1983, in fact, contemplated and looked at both sort of mob power and governmental power, and said, if you are using state power to violate people's rights, an individual can go to court and get justice. And, I think in the SB 8 case, Justice Sotomayor said, the court was turning its back on kind of this promise that was crucial to Section 1983. And the issue brief kind of lays out that history, in abundant detail.
And you can check out David's really fantastic work on our website, theusconstitution.org. Thank you so much, David. So much more to talk about. But in conclusion, we at CAC are not afraid to get in the legal weeds and fight it out. And that's because something might not have a sexy name, but it's incredibly important. And one of those things that I want to talk about is the non-delegation doctrine. And we're lucky to have Smita join us again to talk about our work in this case. So as I mentioned, something like the non-delegation doctrine might not be something that people talk about at the kitchen table, but it's incredibly important. And indeed, the conservative legal movement has been using these types of arguments to hamstring the government from putting in place beneficial policies, like, very timely, the vaccine or test rule. Can you talk a little bit about our work in this case to close us out?
Yeah, of course. I'm with you in trying to make non-delegation into more of a kitchen table topic. I mean, it depends on the table, but having some success. I think it's just so important, especially now, to think about giving executive agencies the power to make policies that can really make our lives and our jobs, our workplaces, our economy safer and healthier for everyone. And especially to do that at a kind of quick basis when emergency situations or unexpected situations occur and Congress can't act in time. So in the example that you mentioned about the vaccine or testing mandate, the Biden administration's Occupational Safety Agency, which is called OSHA, issued an order recently that required businesses with a certain number of employees to ask them to either vaccinate themselves or commit to getting weekly tests. And the goal of that rule, which had been researched by this agency, was just to prevent the further spread of COVID in the workplace, where it's been especially devastating. And that rule was quickly challenged, and one of the bases of challenge was what we were just talking about, the non-delegation doctrine. And people have been using this doctrine for a while to challenge the ability of agencies like OSHA to make rules. And that doctrine is based on an idea of constitutional structure, the idea that like the legislature and only the legislature can make laws, and if too much power is given to the an agency in the executive branch, then it would be that agency making laws. And that kind of in theory is one thing, but the conservative legal movement has been using that recently to challenge the ability of agencies to make rules, even when Congress sort of envisioned them doing exactly that. So in a case like this, Congress can't really figure out exactly when and how workplaces should protect themselves against the spread of COVID. So it's extremely appropriate, and they created legislation giving OSHA the power to make rules like that. And in our brief, we kind of tackle the historical argument that a lot of these conservative legal scholars make about non-delegation. We argue that the doctrine as they portray it is really not aligned with what the founders of the Constitution envisioned. And we've actually contributed briefs to many non-delegation cases, demonstrating that even in the 1700s, like the first and second Congresses, those legislators were really comfortable delegating broad amounts of power to the executive branch to make determinations, as long as the statute gave some kind of guidance to say, give a little bit of instruction to the president or the people who worked for the president. Those early legislatures were really comfortable delegating power. And I think they recognize what we were just talking about, which is that executive agencies might be in the best position to really act quickly and process information and at a speed in which the federal legislators really couldn't act. So we contributed a couple of different examples that we hope will really guide the court as they evaluate these challenges to the vaccine or testing mandate, and kind of portray that mandate as in line with exactly what these early legislators envisioned.
Yeah, thank you. I think it's so important, as you note, to talk about the ways in which, defending the ability of executive agencies to carry out the law, is really in line with what the Constitution was set up to do. It was set up for a federal government that can provide national solutions to national problems. And they envisioned a working executive. So even though some of the growth of the administrative state is new, the way that conservatives portray it as kind of this new, extra constitutional apparatus is really inaccurate. So I'm grateful that we're putting forth this story, because even if the things like the non-delegation doctrine are not talked around around the kitchen table, certainly the ability of executive agencies to do their job and put beneficial policies in place affects the safety of the food on your table, the cleanliness of the water that you're drinking from that table, the air that we breathe, our ability to be safe in our workplaces, and it's so important. So thank you, Smita, again for joining us.
Yeah, and I'll just add one thing. Thank you so much. As you're explaining this work and the importance of this case, and even the relevance of non-delegation to individuals who might not understand non-delegation otherwise or chat about it, it's coming on a week where we realize the sort of grim milestone that 800,000 members of the American family are no longer with us because of an ongoing pandemic. And what is at stake when we talk about the ability of this rule to make our workplaces safer is very real, is painfully real for us this week. So thank you for the work, not only making sure our federal government can work in the abstract and sort of protect members of the American family, but particularly now in the ongoing pandemic.
Yes, so thank you so much to everyone from Team CAC who joined us today. Thank you for joining us for this great conversation. Thank you to my child who's just joined us to say goodbye. And thank you for supporting us throughout this year and being part of our conversation. We look forward to having more in the next year. And you can check out, as always, CAC's work at theusconstitution.org. Please be well.